accroché à son siège de leader de l'opposition, avait tourné la démocratie en ridicule et avait fait, comme ils aiment à dire, vous aussi vous aimez à dire que c'est un temple of democracy. Mais qu'est-ce qu'ils n'ont pas fait de ce temple of democracy? Pendant, allons dire, presque une année, en 2014, ce temple of democracy était vide, ne siégeait pas. Mais au-delà de cela, les Mauriciens constatent comment, semaine après semaine, les membres de l'opposition agissent mal dans cette chambre. Ils insultent les speakers, font fi des standing orders, provoquent des walkouts ou encore cherchent l'expulsion. Monsieur le Président, aujourd'hui, ils sont venus, certains je dois dire, hein, pas tous, ils sont venus, j'apprends, prendre leur petit déjeuner à l'Assemblée nationale. Prendre leur petit déjeuner pour ensuite aller en dehors de la Chambre pour aller manifester. Qui plus est, Monsieur le Président, pendant que nous sommes en train de travailler, et nous travaillons avec sincérité, nous travaillons dur, et lorsqu'on est arrivé à l'heure du déjeuner, c'était vite là-bas. Mais est-ce que vous savez, Monsieur le Président, certains ont pris leur déjeuner en takeaway? Attention, je ne dis pas qu'ils n'ont pas droit à leur petit déjeuner ou déjeuner. Mais lorsque vous boycottez les débats à la Chambre, au moins ayez la décence de ne pas être, je vais utiliser ce mot en créole, des véritables crévères. Je dois dire, c'est un cinéma de mauvais goût qui est condamné par la majorité de nos compatriotes qui s'interrogent avec raison si les membres de l'opposition peuvent toujours toucher leur salaire et leur boni de fin d'année. Cela étant dit, Monsieur le Président, l'absence honteuse de l'opposition ne m'empêchera pas à fournir des explications sur les points soulevés et dénoncer les fausses propagandes, la mauvaise foi et le vrai agenda de certains. Mr. Speaker, sir, first of all, I would like to thank all the honourable members from both sides of the House who have taken the floor and contributed to the debate over this very important bill, which is indeed a landmark in our fight against financial crimes. As I explained in my second reading speech, this bill is a bold, decisive, and proactive step by the government towards the integration of key agencies into a single apex body, which will foster greater synergy and coordination in investigations and prosecution of financial crime offences and in the confiscation of illicit assets. The new framework proposed in the bill acknowledges the dynamic nature of financial crimes and incorporates appropriate mechanisms to assess evolving trends and stay ahead of current and emerging threats. We have no doubt that this bill will contribute to enhance the effectiveness of the financial crime strategy, thereby increasing public confidence in the stability and integrity of our financial sector. It also reflects our commitment and engagement to fulfill our international obligations and our proactive stance in fostering global cooperation. Mr. Speaker, sir, I have listened carefully to the different speakers who intervened on this bill. And I must say that while some of them have made meaningful contribution to the debate, others, mostly from the other side of the House, sadly enough, have engaged themselves in cheap and petty politics. Although the bill comprises 169 clauses, they have chosen to focus only on a few clauses, mainly clauses 10, 66, and 142. Because of their tunnel vision approach and lack of perspective, they could not see the forest for the trees. They either missed the point completely, or they have been deliberately misinterpreting things only with the intention of creating fear and doubts in the minds of the people. What they see as dangers to civil liberties in the bill is only a figment of their imagination. This bill, Mr. Speaker, sir, is targeting only the corrupt, the fraudsters, crooks and criminals, drug dealers, scammers, those who have accumulated unexplained wealth or ill-gotten gains and the likes. They are the ones who have to fear. But honest people of this country have nothing to fear from the bill. It is meant to protect them and the country. And I have no doubt that the majority of the people of this country understand that. And they also understand the demagogy and hypocrisy of this opposition. Anyway, members from this side of the House have given a fitting rebuttal to their arguments. Nevertheless, I would like, on my part, to respond to a few points which have been raised in order to dispel any remaining doubt, fear, or confusion which their arguments may have created in the minds of some people. Mr. Speaker, sir, let me first take the issue which has given rise to much apprehensions, or should I say, misapprehensions in the minds of the opposition. In fact, the opposition has made a lot of hue and cry, both inside and outside the House, over clause 142 of the bill, which is vesting the FCC with prosecutorial powers. The leader of the opposition and a few others questioned the constitutionality of the provisions of clause 142 and queried about the rationale and justifications for vesting the FCC with prosecutorial powers. I think some of them have either misread the relevant provisions of the bill and the Constitution, or they are deliberately trying to instill fear and doubt in the minds of people. Mr. Speaker, sir, let me restate most emphatically that this bill is not curtailing any of the powers of the DPP under Section 72 of the Constitution, which is not being touched at all. Moreover, the provisions of Clause 142 of the bill do not, in any manner, contravene the provisions of Section 72 of the Constitution. The bill is only vesting the FCC with prosecutorial powers, which is constitutionally and legally in order. The overriding and ultimate objective of Clause 142 is to protect the integrity of our financial sector by reducing delays in bringing the perpetrators of financial crimes to justice and securing convictions in the interest of all parties concerned, and also consolidating our AML CFT framework in anticipation of the FATF evaluation exercise scheduled for 2027. Mr. Speaker, sir, there is absolutely nothing sinister or controversial in conferring prosecutorial powers to the FCC in order to enable it to institute and undertake criminal proceedings in its own name against any offender for any criminal offense under the FCC Act or the Declaration of Assets Act. Mr. Speaker, sir, the advisability of vesting the FCC with prosecutorial powers is an issue that was carefully examined by the Attorney General's office, which has also consulted eminent and experienced jurists on this matter. The question was examined particularly in the light of the powers of the DPP under Section 72 of the Constitution. As the House is aware, Section 72, subsection 3 to subsection 5 of the Constitution set out the powers of the DPP with regard to the institution and conduct of prosecution for criminal cases. These sections read as follows, and I quote, subsection 3. The Director of Public Prosecutions shall have power in any case in which he considers it desirable so to do to A. Institute and undertake criminal proceedings before any court of law. B. Take over and continue any such criminal proceedings that may have been instituted by any other person or authority. The emphasis is mine. And C. Discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. Again, the emphasis is mine. Subparagraph 4. The powers of the Director of Public Prosecutions under subsection 3 may be exercised by him in person or through other persons acting in accordance with his general or specific instructions. Subparagraph 5. The powers conferred upon the Director of Public Prosecutions by subsection 3, B, and C shall be vested in him to the exclusion of any other person or authority, provided that where any other person or authority has instituted criminal proceedings, nothing in this subsection shall prevent the withdrawal of those proceedings by or at the instance of that person or authority at any stage before the person against whom the proceedings have been instituted has been charged before the court, unquote. Mr. Speaker, sir, it follows that Section 72, subsection 3 of the Constitution does not confer upon the DPP the exclusive right or monopoly to institute criminal proceedings. Section 72(5), in fact, confers constitutional powers to the DPP to take over, continue, or discontinue any criminal proceedings instituted by any other person or authority. It is, therefore, constitutionally permissible for any statutory authority to institute criminal proceedings without the consent of the DPP, provided that such powers are conferred upon that authority by law. The consequential effect of Section 72 of the Constitution with respect to Clause 142 of the FCC Bill therefore means that, first, it would be constitutionally permissible for the FCC to institute criminal proceedings without the consent of the DPP for a criminal offense under the Financial Crimes Commission Act after its enactment. Second, the DPP would be constitutionally empowered to take over, continue, or discontinue such criminal proceedings. Indeed, there are already several instances where statutory authorities have been vested with prosecutorial powers. In my second reading speech, I had mentioned as an example that the Food Act 2022 empowers an authorized officer to conduct an inquiry, swear an information, and conduct prosecution before a district magistrate in respect of any offense under the Food Act or any regulations made thereunder. There is no mention in the Act of any mandatory consent of the DPP for the institution of such criminal proceedings before the district court. Mr. Speaker, sir, another instance where the law has vested such powers upon a statutory authority is Section 87 of the Environment Protection Act, which empowers an authorized officer to swear an information and conduct prosecution in respect of an offense under an environmental law before a magistrate. And again, no mention is made for the mandatory consent of the DPP for the institution of criminal proceedings under the Environment Protection Act. Again, I would like to inform the House, and especially Honorable Utim, who is not here in particular, that the Environment Protection Act of 2002 was introduced by his colleague, Honorable Bhagwan, with the blessings of his leader. A further example would be Section 43 of the Waste Management and Resource Recovery Act, which also empowers an authorized officer to swear an information and conduct prosecution without the consent of the DPP in respect of an offense under that act before a magistrate. Mr. Speaker, sir, I would like to underline the fact that no questions were raised in this House regarding the constitutionality of the proposals to vest the authorized officer other than the DPP with prosecutorial powers under this free legislation I have just mentioned. Moreover, the offenses committed under these free legislation are not merely minor offenses, not to say fixed penalty offenses that carry fixed penalties of 500 to 1,000 rupees, for example. Under the Food Act of 2022, the penalty is a maximum of 100,000 rupees and imprisonment for a term not exceeding 2 years. In the Environment Protection Act, the fine is a maximum of 500,000 rupees and imprisonment not exceeding 12 years. And as regards the Waste Management and Resource Recovery Act 2023, the fine is a maximum of 200,000 rupees and imprisonment not exceeding 8 years. Therefore, prosecutorial powers without the consent of the DPP have always been entrusted to those authorities with respect to major and serious and not minor offenses. Mr. Speaker, sir, I would further like to point out that irrespective of the legislation that I have made reference to, there is no legal requirement for the police to seek prior consent of the DPP for the lodging of cases before the district court, as has been mentioned earlier by the Attorney General. Unlike cases that are lodged before the intermediate court, which need the fiat of the DPP pursuant to Section 112 of the Courts Act. On the one hand, The law provides that cases that are lodged before the intermediate court need the mandatory consent of the DPP, whereas on the other hand, there is no legal requirement for the consent of the DPP to lodge a case before the district court. Therefore, on an assumption that Section 72 of the Constitution conferred an unfettered power for the DPP only to institute criminal proceedings before any court of law, there would have been no need for the existence of Section 112 of the Courts Act. So, why has the legislator provided for Section 112 of the Courts Act? Precisely because the institution of criminal proceedings does not fall under the sole province of the DPP, and other authorities may do so. Mr. Speaker, sir, in regard to the powers and functions of the DPP, I would like, for the benefit of the House, to refer to the views of Professor Stanley Alexander de Smith, who was the Constitutional Commissioner for Mauritius and who drafted our Constitution at the time of our independence. In a paper of the Law Reform Commission of Mauritius, dated March 2009, entitled, I quote, "The Office of Director of Public Prosecutions and the Constitutional Requirement for its Operational Autonomy," unquote, the Law Reform Commission stated that the framers of our Constitution adopted the best constitutional practices that had then emerged in the new Commonwealth. The Law Reform Commission then extensively quoted and referred to Professor de Smith's book entitled, I quote, "The New Commonwealth and Its Constitutions," unquote, in which Professor de Smith expressed his views on the constitutional powers of the DPP as follows, and I quote, "In instituting, conducting, taking over, continuing and discontinuing prosecutions, the DPP is not to be subject to the direction of any person. And in the exercise of all of these functions, other than that of instituting prosecutions, his responsibilities are to be exclusive," unquote. So, Mr. Speaker, sir, it is clear and unambiguous from the wordings of Professor de Smith that the DPP does not have exclusive powers of prosecution under Section 72 of our Constitution. Mr. Speaker, sir, I would also like to refer to an article by a former DPP, Mr. Cyril de la Beauve d'Arifat, entitled, I quote, "Le directeur des poursuites publiques," unquote, published in the Mauritius Law Review of 1978. Mr. D'Arifat was occupying the post of DPP in the 70s, and his article has very often been used as a guide and reference. In his article, Mr. D'Arifat stated the following, and I quote, "La Constitution se contente de prévoir que le DPP pourra, quand cela lui paraît opportun, intenter des poursuites, continuer celles qui auraient déjà été intentées par quelqu'un d'autre, stopper tout procès pénal avant le prononcé du jugement et même après le jugement, s'il y a appel et que l'accord de l'appelant a été obtenu. En effet," and the underlining is mine, "le DPP n'a pas, en droit mauricien, l'exclusivité ou le monopole d'intenter des procès." End of quote. It is clear, therefore, that under the Constitution, the DPP does not have the exclusivity or monopoly to institute criminal proceedings, and that other persons or authority can also initiate and bring prosecutions as provided under Section 72(3) of our Constitution. Mr. Speaker, sir, because I'm going to quote all this because I understand and I hope also that this opposition will go before the Supreme Court and eventually before the Privy Council. Let me probably, laissez-moi freiner leurs ardeurs. Any debate or uncertainties concerning the possibility of other person or authority, apart from the DPP to institute criminal proceedings, have been laid to rest by the Judicial Committee of the Privy Council in its landmark judgment in the case of Commissioner of Police versus Tedroy Benjamin. This is a judgment dated 16th of April 2014 and unanimously delivered by 5 law lords on an appeal coming from Antigua and Barbuda. In this case, the law lords had the opportunity to give judicial consideration and to determine the scope and ambit and interpretation to be given to Section 88 of the Constitution of Antigua and Barbuda, which concerns the constitutional powers of the DPP. This judgment has a direct bearing in Mauritius, as Section 88 of the Constitution of Antigua and Barbuda is identical to Section 72 of our own Constitution. The issue that the law lords had to thrash out in this case is actually very relevant and pertinent to the issues which have been under discussion around the FCC bill. In the Antigua and Barbuda case, the issue was whether the DPP had the power to prevent the police from instituting criminal proceedings, which they were empowered to do under the Police Act. The law lords authoritatively laid down the following propositions and judicial determinations concerning the constitutional powers of the DPP of Antigua and Barbuda, which I must repeat is identical to the constitutional powers of the DPP under our own Constitution. 1. The DPP has the constitutional power to institute criminal proceedings in any court, and if he exercises his power, he does so in his own name. And in that, it is a power rather than a duty. The DPP can elect not to exercise it. In other words, not to institute such proceedings. 2. The Constitution expressly recognizes that criminal proceedings can be instituted by a person or authority other than the DPP. 3. No express power is given to the DPP under the Constitution to control the exercise of the powers of any other person or authority to institute criminal proceedings. 4. The power of the DPP to institute criminal proceedings cannot be construed as a power to prevent exercise of the power to do so expressly recognized elsewhere in the section by any other person or authority. 5. The Constitution does not enlarge the powers conferred on the DPP when it provides that the functions of the DPP can be exercised by him in person or through other persons, acting under and in accordance with his general or special instructions. This only addresses the mode of the exercise of his powers. 6. The law lords held further that under the Constitution, criminal proceedings can also be instituted by private persons and by authorities other than the police. For example, the Inland Revenue and the Immigration Department. And although such proceedings can be discontinued by the DPP, it is not suggested that he has power to prevent private persons and those other authorities from instituting them. Logically, therefore, the suggested power to prevent cannot be derived from the power to discontinue. 7. It was also held that the DPP exercises his power to discontinue criminal proceedings by taking a formal, publicly visible step in the proceedings which can be challenged by judicial review. An instruction by the DPP to the police not to institute proceedings would also, in theory, be susceptible to judicial review, but would often lack the public visibility which would alert potential applicants to the possibility of challenge. 8. Finally, the law lords held that a statement issued by the DPP to the effect that the DPP remains solely responsible for the taking of all prosecutorial decisions and the police remains solely responsible for the conduct of investigation is wrong in law. Mr. Speaker, sir, there is another judgment of the Judicial Committee of the Privy Council in the case of Commissioner of the Independent Commission of Investigations versus Police Federation, dated the 4th of May 2020. This judgment was also unanimously delivered by 5 law lords on an appeal coming from Jamaica. The issue to be decided in that case was whether the legislature intended to give to a statutory commission express general prosecutorial powers and functions in addition to its investigative role. In this case also, it is important to note that Section 94 of the Jamaican Constitution is identical to Section 72 of our own Constitution concerning the powers of the DPP. The Supreme Court of Jamaica held in that case that the powers vested in the commissioner and officers of that commission to arrest, charge, and prosecute offenders in no way undermine the constitutional authority of the DPP, who still retain his power to take over and or to discontinue any prosecution. The law lords on appeal held in this case that the legislature could have conferred through an act of parliament to a statutory commission the power to arrest, charge, and prosecute offenders. The intention of parliament to give such prosecutorial powers and functions must be clearly expressed in the provisions of the act of parliament providing for such prosecutorial functions. It means, therefore, that vesting of prosecutorial powers under an authority other than the DPP is a policy matter to be decided upon by the executive. Mr. Speaker, sir, I would also like to mention a ruling given by the High Court of Fiji in 2008 in the case of the Fiji Independent Commission Against Corruption, FICAC, versus Inoke Devo, in which the court confirmed that, and I quote, the FICAC or any other body or person, whether created by statute or not, has common law powers to prosecute. This is acknowledged by the Constitution, and the right is specifically provided for in the Criminal Procedure Code. It is quite clear that the Director of Public Prosecutions does not have exclusive rights to prosecute. He only has exclusive rights to intervene in someone else's prosecution and to discontinue such prosecution. Section 96(4) specifically provides for the existence of prosecutions brought by persons other than the DPP, unquote. Mr. Speaker, sir, it is also to be noted that the powers of the DPP under Section 114(4) of the Constitution of Fiji are similar to those under Section 72(3) of our own Constitution. We continue. Let's move on. I would like now to mention a ruling given by the Supreme Court of Seychelles on 19th of November 2021 on a motion filed by the Anti-Corruption Commission of Seychelles seeking leave of the court to conduct a prosecution against two suspects under Section 64 of the Anti-Corruption Act of 2016. The judge of the Supreme Court of Seychelles made the following pertinent observations in relation to the powers and functions of the Attorney General. There, the Attorney General is vested with prosecutorial powers similar to our DPP here in Mauritius. And I quote, "I note that the Anti-Corruption Commission is a prosecuting authority. It is endowed with prosecuting powers. This is so by virtue of Section 64 of the Act, which provides that prosecution for an offense under Part 3 of the Act may be instituted by the Commission. The former provision that subject a prosecution to the consent of the Attorney General was deleted and replaced with the actual provision. This power to prosecute has to obviously read to and has to be in accordance to Article 76(4) of the Constitution, which gives prosecuting powers to the Attorney General and makes him the national prosecuting authority. However, reading this Article 76(4) of the Constitution in its entirety leads me to conclude that though the Attorney General is the principal prosecuting authority, he is not the sole prosecuting authority in this country. This is clear upon a reading of Article 76(4)(b) and (c) of the Constitution. Article 76(4)(b) can be paraphrased as follows. The Attorney General shall have power in any case in which he considers it desirable to do so, to take over and continue any criminal proceedings that have been instituted or undertaken by any other person or authority. Whilst Article 76(4)(c) provides that the Attorney General shall have the power to discontinue at any stage before judgment is delivered any criminal proceedings instituted or undertaken by any other person or authority. By necessary implications, therefore, Article 76(4)(b) and (c) of the Constitution grants constitutional power to a person or authority to prosecute criminal cases by instituting or undertaking criminal prosecutions. The only power of the Attorney General over these prosecutions are supervisory, that is, to take over and continue or to discontinue at any stage any prosecutions otherwise commenced by any persons or authority before judgment is given. The Anti-Corruption Commission is a statutory authority which read with Section 64 of the Act and Article 76(4)(b) and (c) has power to prosecute in its own cases under its own name, unquote. Mr. Speaker, sir, this ruling from the Seychelles Supreme Court goes in the same direction of the previous judgments I mentioned earlier regarding vesting of prosecutorial powers in statutory institutions other than the DPP. However, Honorable Paul Béranger, who, on Friday last, he mentioned the example of Seychelles regarding the mode of appointment of the head of the anti-corruption agency. But he made no reference to the fact that the anti-corruption agency is vested with prosecutorial powers. Monsieur le Président, je dénonce ici la mauvaise foi de l'honorable Paul Béranger, qui a choisi d'être sélectif en se référant au modèle séchellois. Mr. Speaker, sir, there are several other authoritative sources which support the provisions of Clause 140 2 of the FCC bill. In the third edition of the OECD report, published in 2017, entitled, I quote, "Effective Interagency Cooperation in Fighting Tax Crimes and Other Financial Crimes," unquote, on the aspects of prosecution authority for financial crimes. Prosecution authority has been defined as the government agency that represents the state before courts in prosecutions of criminal offenses. The report argues that agencies responsible for investigating offenses may have competency to conduct prosecutions directly, and countries like New Zealand have adopted such models. The advantages of this model is that, firstly, each agency has a high degree of specialist skills with respect to its area of focus, which enables prosecution to be conducted by experts in a particular area of criminal law. Secondly, by controlling their own prosecution, agencies also benefit from greater autonomy in decision-making and flexibility in setting their strategic direction, with less direct competition for the resources of a central public prosecutor. In Germany, for example, tax administrations have responsibility for conducting prosecutions of all tax offenses, while in Australia, the Australian Taxation Office has authority to prosecute offenses. In Singapore, the Inland Revenue Authority can prosecute income tax offenses directly. In Sweden, the Customs Administration has a small number of prosecutors who are able to directly prosecute cases. Mr. Speaker, sir, the UK Serious Fraud Office, commonly known as the SFO, is perhaps the most notable and comparable example abroad of a specialized and expert enforcement agency against financial crime, which is vested with special investigative and prosecutorial powers. The SFO was established in 1988 by virtue of the Criminal Justice Act as a specialist body dealing with the most serious cases of fraud, bribery, and corruption. It is one of United Kingdom's biggest law enforcement agencies, having both investigative and prosecutorial powers and functions. It has on its staff a number of experienced investigators, barristers, and solicitors. Mr. Speaker, sir, the SFO is a good example with which we can compare the FCC, given the similarity of their respective mandate. The development of the FCC model was supported throughout by the United Kingdom SFO and National Crime Agency. After completing an inquiry into a matter, the SFO does not send the file to the Crown Prosecution Service for charge or prosecution. Ever since its inception, the Serious Fraud Office was meant to deal with a case from cradle to grave, as they call it there. It means that the SFO takes in intelligence referrals, and in case it decides to formally start an investigation, the case stays with it for investigation, charging decisions, prosecution, and all ancillary matters, including proceeds of crime, namely restraint, forfeiture, confiscation, and compensation. Mr. Speaker, sir, the SFO was set up specifically to work in this unique way, and there were some good reasons for that, which are very relevant for the purpose of our discussions. As a matter of fact, the SFO was established in 1988 following the Roskill Report of 1986, which had recommended the setting up of a single unified organization responsible for all the functions of detection, investigation, and prosecution of serious fraud. Mr. Speaker, sir, let me quote the relevant part of the Roskill report, which is very pertinent in the present debate, as it authoritatively answers the questions raised by members of the opposition, both inside and outside this House, regarding the rationale and justification for vesting the FCC with prosecutorial powers. The report says, and I quote, "We consider it essential that the team of specialists involved in any substantial fraud investigation, including investigations by the Inland Revenue or Customs and Excise, is given expert direction by one or two highly skilled lawyers. Unless advice of high quality is available from the outset of investigations of this type, the inquiries will be slowed up and valuable time may be wasted pursuing the wrong lines of inquiry. It is undesirable that the investigation should take one course, and for that course to be found not to be the right one by counsel who is brought in to prosecute only at a much later stage, perhaps after the case has been committed. Counsel who are appointed during the investigation stage should be the counsel who are to conduct the case at any subsequent trial, so that the same person who has given the inquiry direction will be involved in the presentation of the prosecution. A considerable advantage of involving counsel from the beginning is that he will have had the opportunity of becoming familiar with the case, and less of time will be taken up at the stage when the case is being prepared for trial," unquote. The SFO, therefore, does not refer cases or decisions to the DPP or the Crown Prosecution Service. The director of the SFO is already empowered under Section 1(5) of the Criminal Justice Act 1987 to initiate criminal proceedings. It is noteworthy that the director can also delegate his powers under the Act, but he can do so only to members of the SFO, not outside the SFO. That is, he cannot delegate or pass the charging decision on an investigation to the DPP or the Crown Prosecution Service. It is equally of note that under the Bribery Act 2010, the SFO is vested with powers to give consent to prosecute offences under that Act. In fact, Section 10 of the Bribery Act provides that such consent may be given either by the DPP or the Director SFO. That section further specifies that when the Director SFO is unavailable, the consent power may be delegated only to another person within the SFO. It is also apposite for me to mention here that the Director SFO is appointed by the Attorney General, who is a political figure. The appointment is made under Section 1(2) of the Criminal Justice Act 1987. The DPP is also appointed by the Attorney General, albeit under different legislation. The CPS and the SFO sit as separate arm's length bodies under the Attorney General's office. Mr. Speaker, sir, in addition to the SFO, there is in the United Kingdom the Financial Conduct Authority, commonly known as the FCA, which is a body established under the Financial Services and Markets Act of 2000. It is an expert and specialized body which regulates the United Kingdom's financial services industry. The FCA is also vested with both investigative and prosecutorial powers and functions. Therefore, Mr. Speaker, sir, we see no legal or constitutional impediments in Clause 142, inasmuch as it is a current practice in several comparable jurisdictions for statutory institutions to be vested with prosecutorial powers. Mr. Speaker, sir, members of the opposing side have in their interventions tried to make believe that this bill is vesting too much power upon the Director General, more specifically powers to institute criminal proceedings for a financial crime. My colleague, Honorable Ganu, had already replied to this. I would call it a very frivolous argument. But let me make it clear that the Director General has no power at all to institute or not to institute criminal proceedings, but rather it will be for the Financial Crimes Commission, comprising of 5 persons with diverse competencies and professional background, to determine whether or not to institute criminal proceedings. It will not be the decision of an individual, as it would if a case were referred to the DPP. We are here talking about the collective decision of a commission of 5 persons, as compared to the decision of one individual person in the DPP. Furthermore, there are several procedures and safeguards that have to be followed by the FCC before any decision is taken by the Commission. Mr. Speaker, sir, allow me to refer again to clause 142, 1A of the bill, which reads as follows, and I quote, 1A. Following the conclusion of an investigation and the receipt of a report under Section 58, the Commission may institute such criminal proceedings as it may consider appropriate for any offense under this Act or the Declaration of Assets Act, unquote. Therefore, the Commission needs to be in presence of a report, and such report would contain the conclusions of the investigation and any advice that may have been tendered by the Chief Legal Advisor. There is a whole process starting from investigation and the legal and evidential aspect of the investigation being considered by the legal division, which shall tender its legal opinion before a report is submitted to the Commission for it to reach a decision. It is obvious that several safeguards have been put into place in the bill before the Financial Crimes Commission makes a sound and reasonable decision. Mr. Speaker, sir, Honorable Paul Béranger stated on Friday last that government is not amending Section 72 of the Constitution because it does not have the required majority. Mr. Speaker, sir, we are not amending Section 72 for the simple reason that it is not necessary at all, as Section 72, 3 and 5 already provides that any other person or authority apart from the DPP can be vested with prosecutorial powers. Therefore, the question of amending Section 72 simply does not arise. Mr. Speaker, sir, during his intervention, Honorable Shakil Mohammed stated that I should clarify whether, under the provisions of the FCC bill, the DPP would be entitled or allowed to intervene at the stage of a provisional charge, or to specify at what specific point in time during a criminal proceeding the DPP would be able to intervene under the powers conferred upon him by Section 72, 3B and C of the Constitution. Mr. Speaker, sir, I thought Honorable Mohammed, who is a lawyer, I thought he was or at least following the issues that are before the court right now, because I hope he is also not selective in putting the questions, because this is a matter which is being argued now before the Supreme Court. Therefore, for me to reply to this question of Honorable Mohammed would be tantamount for me to be usurping the powers of the Supreme Court, which is the sole authority entitled to interpret the provisions of our Constitution. The more so, as I say, that there is a case pending before the Supreme Court where the Commissioner of Police is seeking constitutional redress against a decision of the DPP. So only the Supreme Court, as guardian of our Constitution, is entitled to give an interpretation as to the precise meaning of criminal proceedings in the context of our local criminal law system and under our Constitution, and clarify at what specific point in time exactly criminal proceedings is deemed to start under our system according to the provision of Section 72, 3B and C of the Constitution. Mr. Speaker, sir, another issue on which almost all the speakers from the opposition, especially Honorable Béranger, Honorable Boda, and Honorable Ramphal, have raised concerns, although unjustified, is in relation to the power that is being vested in the FCC to use special investigative techniques, including intrusive surveillance, for the purpose of gathering intelligence or evidence. Their reactions and comments and criticisms in regard to this proposal only betray their ignorance about the drastic changes in the financial crime landscape over the recent years. As I stated in my second reading speech, such tools and techniques are indeed essential if we are to increase the effectiveness of our fight against financial crimes in this digital era. The opposition questioned the need for the FCC to be vested with special investigative powers, which Honorable Boda called pouvoir d'exception. In this context, Honorable Ramphal referred extensively to the position of Honorable Kolenda-Velu in 2001, when the latter was chairing the Select Committee on the setting up of the ICAC, stating that Honorable Kolenda-Velu was very much against the idea of vesting prosecutorial and greater investigative powers upon the ICAC, and that today he has changed his stand and he is now supporting the FCC bill. Well, all that I can say is that Honorable Kolenda-Velu reckons with the fact that the financial crime landscape has changed drastically over the last 20 years. And I must say he is wise enough to change his position now. Monsieur le Président, à l'époque où l'ICAC allait être créé par le biais de la Prevention of Corruption Act, des discussions avaient eu lieu sur la nécessité ou non de donner à l'institution des pouvoirs de poursuite. Cela d'ailleurs m'a été confirmé par l'honorable Kolenda-Velu. Puisque c'était une nouvelle institution, il y a eu un consensus à cette époque pour ne pas la donner de tels pouvoirs. Mais avec le temps et l'expérience vécue par l'ICAC en ce qui concerne l'efficacité de ses actions et aussi l'évolution des crimes financiers, la nécessité de donner ces pouvoirs à la nouvelle institution que sera la FCC s'est révélée. C'est pourquoi, lors des discussions que nous avons eues avant la préparation du projet de loi, il a été décidé de donner des pouvoirs de poursuite à la FCC. Mr. Speaker, sir, as someone has rightly said, a wise man changes his mind sometimes, but a fool never. To change your mind is the best evidence that you have one. Indeed, in a dynamic and ever-changing world, our institutions need to evolve and adapt to new realities so as to remain fit for purpose. Mr. Speaker, sir, financial investigation constitutes an essential component of any financial crime strategy. Any attempt to modernize and strengthen a country's financial crime strategy should sufficiently emphasize financial investigation as an integral part of law enforcement efforts. Accordingly, there should be clear objectives, dedicated action, sufficient resources, training for investigators, and the use of legal tools available in a comprehensive, creative, consistent, and committed manner. These are all important elements of an effective financial investigation strategy. As a matter of fact, controlled remittance exercise and surveillance are investigative techniques already being used by the ICAC and the police to identify and uncover offences. My colleague, Honorable Attorney General, has given a fitting reply to those queries of the opposition. But let me say that the use of intrusive surveillance is a power that the police already have under the Dangerous Drugs Act. Those techniques are recognized through case laws in Mauritius as well as across the world by law enforcement agencies. For instance, the SFO in the United Kingdom uses similar tools and techniques. In fact, there is nothing sinister in providing such powers to a financial crime agency, vested with the function to investigate into serious offenses such as corruption, bribery, money laundering, fraud, and financing of drug dealing. In order to ensure effectiveness in the fight against financial crimes, it is important for it to have such powers to be able to detect, identify, and gather evidence for such offences. At any rate, Mr. Speaker, sir, intrusive surveillance will require a judge's order before it can be used. There are several international organizations which advocate the use of controlled remittance and surveillance techniques in the fight against financial crime. In fact, Mauritius will be examined on these issues in the forthcoming FATF mutual evaluation and the OECD working group on bribery peer review. For example, FATF recommendations 30 and 31, as well as immediate outcome 7, clearly lays down the obligation for countries to use a wide range of investigative techniques, which include undercover operations, intercepting communications, accessing computer systems, and controlled delivery. Countries can implement these requirements within their legal systems. These specialized techniques are used in many countries across the world in their law enforcement strategy and legislation. Mr. Speaker, sir, I would like to quote from the FATF President's paper of June 2018, entitled, I quote, Anti-Money Laundering and Counter-Terrorist Financing for Judges and Prosecutors, unquote, regarding investigators' powers and techniques, which says, and I quote, experts stress the importance of competent authorities conducting investigations of money laundering, associated predicate offenses, or terrorist financing, being able to access all necessary documents and information for use in those investigations and prosecutions. This should include available compulsory measures to obtain records held by financial institutions, designated non-financial businesses and professions, and other natural or legal persons. Search of person and premises, take witness statements, and seize and obtain evidence. The FATF standards also requires jurisdiction to be able to use a wide range of other investigative techniques, some of which entail more specialized expertise, such as undercover operations, intercepting communications, accessing computer systems, and conducting controlled deliveries, unquote. Mr. Speaker, sir, I would also like to quote from the ESAMLAG Mutual Evaluation Report of July 2018, which states as follows on overall conclusions on immediate outcome 7, and I quote, Mauritius has used its legal and institutional framework to investigate and prosecute money laundering offenses. However, the outcome of money laundering investigations and prosecutions did not appear to be in line with the risk profile of the country. In addition, there was no evidence that authorities, except in ICAC, regularly pursue money laundering in conjunction with a predicate offense, third-party money laundering or self-laundering. Although the DPP's chambers had a general knowledge of money laundering, they did not have any cases to demonstrate that they were able to determine and prosecute the various types of money laundering, and they had not prosecuted any foreign predicate offenses, unquote. Mr. Speaker, sir, it is equally of note that one of the key factors taken into consideration by the United Nations Office on Drugs and Crime in effectively fighting corruption is the implementation of Article 50 of the UNCAC. Mauritius, as we all know, is signatory to the UNCAC. Now, what does Article 50 say? Mr. Speaker, sir, Article 50 expressly provides that in order for state parties to combat corruption effectively, they shall take such measures as may be necessary within its means to allow for the appropriate use by its competent authorities of controlled delivery, and where it deems appropriate, other special investigative techniques such as electronic or other forms of surveillance and undercover operations within its territory, and to allow for the admissibility in court of evidence derived therefrom. So what is this issue about? They are emphasizing on special investigative techniques, as if they are discovering. They are now born, and they are discovering this term, how you call it, this term today, which has been used by the UNODC, by so many of the international institutions. Mr. Speaker, sir, these techniques are especially useful in dealing with sophisticated, organized criminal groups because of the dangers and difficulties inherent in gaining access to their operations and gathering informations and evidence for use in domestic prosecutions, as well as providing mutual legal assistance to other states' parties. In many cases, less intrusive methods will simply not prove effective or cannot be carried out without unacceptable risks to those involved. Mr. Speaker, sir, as the House is aware, Mauritius has become a participant member of the OECD Working Group on Bribery since February 2023. It has 2 years as from that date to bring necessary amendments to its legal framework in combating corruption and foreign bribery, so as to make it eligible to accede to the OECD Anti-Bribery Convention. One of the key factors and consideration by the OECD under Article 5 of the Anti-Bribery Convention is that investigators should have a range of investigative measures, including power to deploy special investigative techniques, that is, covert techniques, in order to effectively fight foreign bribery. Mr. Speaker, sir, the United Kingdom government, through the British High Commission in Mauritius, is providing technical support to Mauritius, such that the country can accede to the OECD Anti-Bribery Convention. Accordingly, GovRisk, which is a UK-based consultant, carried out an assessment of Mauritius' compliance with the OECD Anti-Bribery Convention earlier this year and submitted its report with a range of recommendations with a view to improving the legal framework in Mauritius to fight corruption and foreign bribery. GovRisk has made the following observations. 1. The POCA 2002 only provides for specific investigative powers and tools, and Mauritius does not have a dedicated law on the use of special investigative techniques. The legal basis, the deployment of special investigative technique is very limited under POCA 2002, as it provides for specific investigative powers and tools which do not include, for instance, surveillance and other novel techniques. 2. The existing legal basis for the deployment of special investigative techniques is at odds with international standards and puts the investigators and the ICAC at legal risk and may compromise any subsequent prosecution. 3. Intelligence gathering is, by its nature, usually undertaken in a covert and discreet manner. It is important to emphasize that at the stage of collecting intelligence, particularly where special investigative techniques are deployed, agencies acting on behalf of the state are required to undertake their activities in compliance with human rights law and ensure that any intrusive deployment is lawful, necessary, and proportionate. No state agency acts in a legal vacuum, whether it is gathering intelligence or converting it for evidential purposes. Therefore, Mr. Speaker, sir, in order to be in line with international requirements, the FCC, being the specialist agency to investigate financial crimes, is being expressly provided with the power of using special investigative techniques. Those special techniques are very important so as to meet the demands of modern complex financial crimes, including new offense of financing of drug dealing. Indeed, the increasing cyber nature of financial crimes, that is the use of internet by criminals to communicate, organize, conspire, incite, trade, and otherwise facilitate financial crimes, pose special challenges for the law enforcement agencies. Using the internet offers criminals the advantage of no physical risk, greater anonymity, and a wider range of targets. At the same time, virtual currency systems provide a cheap, quick, unregulated, and almost anonymous method of transferring value between individuals or groups anywhere in the world. Also, there are indications of a considerable increase in the use of encrypted communications by criminals across all threat areas and across all levels within crime groups. These are the new realities which, unfortunately, the opposition seems to be oblivious to. Mr. Speaker, sir, we also heard a lot of criticisms from the opposition, particularly from Honorable Béranger and Honorable Boda, against the proposed mode of appointment of the Director General and Commissioners of the FCC. Mr. Speaker, sir, presently Section 19 of the Prevention of Corruption Act provides that the Director General of the ICAC shall be appointed by the Prime Minister after consultation with the Leader of the Opposition. What is being proposed in the FCC bill is that the mode of appointment of the Director General of the FCC be aligned with comparable constitutional and statutory positions, such as the chairperson and members of the National Human Rights Commission, the Competition Commission, the Central Procurement Board, the Procurement Policy Office, the Independent Review Panel, and the Statistics Mauritius. They are all appointed by the President of the Republic on the advice of the Prime Minister after consultation with the Leader of the Opposition. Moreover, there are many other constitutional and statutory positions where appointment is made by the President after consultation with the Prime Minister and the Leader of the Opposition. A few examples are the Electoral Boundaries Commission, the Electoral Supervisory Commission, the Public Service Commission and Discipline Forces Service Commission, the Public Bodies Appeal Tribunal, and the Ombudsman. As a matter of fact, there are at present around 50 constitutional or statutory positions that are filled either by the Prime Minister or after consultation with him or upon his advice. It is noteworthy that the Chief Justice, which is the highest position in our judiciary, is appointed by the President of the Republic after consultation with the Prime Minister. It is also to be noted that the Director of Audit is appointed by the Public Service Commission after consultation with the Prime Minister and the Leader of the Opposition. Moreover, according to Section 89(4) of the Constitution, the Public Service Commission can make an appointment to the post of Secretary to Cabinet and Head of Civil Service, Financial Secretary, Secretary for Home Affairs, Senior Chief Executive, Permanent Secretary, and other supervising officers only if the Prime Minister concurs in it. Mr. Speaker, sir, none of the officers appointed to these positions can be said to be political nominees, just because of the fact that the Prime Minister is directly or indirectly connected with their appointment. And in fact, when the opposition says such things, they are in fact attacking, as they have been doing, the judiciary, because the Chief Justice is appointed, as I have said, by the President, but after consultation with the Prime Minister. So they'll continue to throw mud on independent institutions. Their independence, neutrality, and impartiality have not been and cannot be called into question. Therefore, the argument that the independence of the Director General of the FCC will be questionable only because of the mode of appointment is untenable. Mr. Speaker, sir, on this issue of mode of appointment and independence of the member, by the way, you know, this opposition have had in their ranks two former Prime Ministers, Dr. Navin Ramgoolam and Honorable Paul Béranger. When they were sitting on this side of the House, I have never heard anyone, from either coming from them or from other members, saying that, let us review the mode of appointment of X, Y, Z. No! Everything was fine then. But because they have been sitting, maybe they have been sitting for too long in the opposition, now they have started to say, the mode of appointment is not correct, it has to be reviewed. But anyway, Mr. Speaker, sir, any mode of appointment, any mode, even the one that has been referred by Honorable Béranger, he has come up with 3-4 suggestions. At the end of the day, someone has to appoint somebody. And who has to appoint somebody? While we are in government, we will give that power, that right for the opposition to appoint? What kind of nonsense have they been talking? Anyway, Mr. Speaker, sir, on the issue of mode of appointment and independence of the members of the FCC, I would like to quote a pertinent observation made in a Privy Council judgment in the case of the Belize Bank Limited versus the Attorney General of Belize and others, delivered on 20th of October 2011, in which the Privy Council held, and I quote, I won't go long, I've read this judgment, it's a beautiful judgment, but I will quote, there are in fact very extensive quotes which are of direct interest, both to this House and to the members of the opposition, and to the public. But let me quote only a very few parts of the judgment. And I quote, from time to time, judges are appointed by government ministers to investigate allegations that have been made against the state. It might be said in such cases that the appointing body has an interest in the outcome of the investigation. But it would be absurd to suggest that the fair-minded and informed observer would conclude on that ground alone that there was a real possibility that the appointed judge would be biased, unquote. Therefore, Mr. Speaker, sir, the power of appointment alone does not create any objective absence of independence. Mr. Speaker, sir, some members from the other side, including Honorable Béranger, suggested that the Director General of the FCC be appointed by the JLSC. And my colleague Attorney General has already replied, but I think it's good to repeat so that those who are listening to me, I hope the opposition dans leur salon, ils sont bien rangés, très cosy. Peut-être, quelle heure il est? 3h37, un peu tôt pour certains de prendre un petit... Avec leur takeaway, on va dire. It's good that they listen, JLSC. In the case where appointment has been made by the JLSC, the appointee has been the subject of criticisms by this same opposition. We still recall how the Electoral Commissioner, who is appointed by the JLSC, was openly and vehemently criticized by this same opposition in the wake of the last general election. Les mauvais perdants. These modes of appointment to constitutional positions have stood the test of time and have, to a large extent, guaranteed stability of the institutions concerned. After all, it is the person who makes the institution, and not vice versa. No institution can be better than the person heading it. It is the person who matters and not the mode of appointment. No mode of appointment can guarantee on its own that the appointee will be totally independent and impartial. It all depends on the person. On this issue, I can do no better than quote Dr. Ambedkar, the father of the Indian Constitution, who said, and I quote, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good, unquote. Mr. Speaker, sir, the most straightforward single branch appointment process by the President or Prime Minister to directly select and appoint the head of a financial crime institution has often been associated, although unjustifiably, with a perception of indebtedness to the appointing body, which is likely to impede on impartiality. This is a completely false and erroneous interpretation. There is nothing sinister about the appointment of the head of an agency by the Prime Minister or the President of the Republic. This system is relied upon in many countries in the world, and there is nothing wrong in the mode of appointment, especially when the process for the removal of the head of that agency is done through a separate and strict mechanism and process. The Corrupt Practices Investigation Bureau of Singapore and the Independent Commission Against Corruption of Hong Kong, widely considered amongst the most effective agencies of their kind, use this kind of appointment process. In the United Kingdom, as I stated earlier, the head of the SFO and the DPP are appointed by the Honorable Attorney General, whereas the head of the National Crime Agency is appointed by the Home Secretary. The majority of countries using single branch appointments require at least some consultation with the executive. Furthermore, Mr. Speaker, sir, this misguided perception of the opposition about alleged impartiality often makes abstraction of the checks and balances in the existing provisions in the appropriate law, guaranteeing the accountability and independence of the head and the institution. The FCC bill is making provision for an operations review committee which will act as an oversight body over investigations by the FCC. The parliamentary committee is also being maintained with its existing powers, but the opposition somehow downplayed the importance of this inbuilt accountability mechanism. I must point out that the bill is only vesting in the Prime Minister the power to advise the President on the appointment of the Director General of the FCC. He will not have his say in the termination of the appointment. The bill is providing for a separate and detailed procedure for the removal of the Director General. It is the Parliamentary Committee that is being vested with this power of removal, but under clearly defined and strict requirements and procedures. This aspect of the recruitment process was totally ignored by the opposition in the debate about the independence of the Director General. Mr. Speaker, sir, I would like to react to the accusation made by Honorable Boulel in this House in relation to the provisions of Clause 63(2) of the bill. I heard him insinuating that through Clause 63(2), government is targeting law practitioners. I think he's totally wrong, of course. In fact, similar provisions already exist under Section 51 of the POCA, which enables the ICAC, where it has reasonable ground to believe that a law practitioner has failed to report any suspicious financial transaction, or he has in his possession documents or records which may assist the ICAC. The latter may apply to a judge in chambers for an order allowing the ICAC or any officer delegated by it to enter and search his premises and remove therefrom any document or material. Honorable Boulel seems to be unaware that the legal profession is already regulated as designated non-financial businesses and professions under the AML-CFT framework, in line with the international standards set by the FATF. They already have an obligation to keep records and do customer due diligence, and has reporting obligations to the FIU under Sections 14 and 17C of the Financial Intelligence and Anti-Money Laundering Act, in order to enable detection of suspicious transactions for money laundering offenses. Any such failure may make them liable for an offense under the FIAMLA. Having this obligation means that they have a duty to collaborate in an investigation pertaining to financial crimes. The legal profession should be seen as partners in fighting financial crimes. At any rate, members of the legal profession will be required to disclose relevant information to the FCC only following a judge's order. Mr. Speaker, sir, in regard to the powers of arrest of the FCC, I heard Honorable Paul Béranger in his intervention expressing concern over what he considers to be extensive powers of arrest being vested in the FCC. In fact, he got it all wrong, just as he got it all wrong when he was congratulating some members of his side. When he was referring to Honorable Utim, he mentioned Kader Bayat. But I think he is living, il est en train de vivre un autre temps. Il est resté figé dans le temps, Monsieur le Président. But let that be. I won't comment more on this. But I clearly stated, and I think he hasn't listened, or maybe he cannot recall, he cannot memorize certain things. In my second reading speech, I stated that the FCC is being vested with less, not more, powers of arrest compared to the ICAC. At least he would have, he could have had some time to check whether what I was saying in my second reading speech was correct or not. Mr. Speaker, sir, I would also like to react to the criticisms of Honorable Utim, who spoke about what he considers as poor results of our different anti-corruption agencies. And he tried to make believe that there is very little in terms of achievement, in spite of the fact that I enumerated in my second reading speech the numerous measures taken by the government to consolidate our anti-corruption framework. Mr. Speaker, sir, let me remind the honourable member of some other important measures taken by the government Over recent years, with a view to reinforcing integrity and public trust in our public sector institutions and enhancing transparency and accountability in the management of public affairs. As the House is aware, with a view to modernizing our public procurement system and enhancing transparency and accountability in the process, government has introduced the mandatory use of the electronic procurement system, whereby bidders receive notifications about bidding opportunities by email in real time. They can view the published procurement plan online, as well as submit bids electronically and attend the opening of bids online. Moreover, public bodies are now required to publish a copy of the signed contract agreement, letter of acceptance, bid submission form, addenda, if any, special or particular conditions of contract, and any amendments or variations made during the course of implementation of the contract. In addition, the list of disqualified and debarred bidders, as well as the decisions of the independent review panel, are published on the website of the Procurement Policy Office and are accessible to the public. We have also introduced the Citizen Support Portal, which is an innovative internet platform accessible on the web and the CSU mobile app, and which enables any citizen to either register a complaint or a suggestion or make a query online and track progress on their query and complaint at any time. Since its inception in April 2017 to date, the portal has registered 233,254 complaints, out of which 212,261, that is 91%, have been resolved. In line with our e-government strategy, government has implemented the National Open Data Portal, which houses and provides links to data pertaining to government processes. By opening up data through the Open Data Portal, government aims precisely at promoting transparency in as much as citizens are able to freely access information on government activities. Mr. Speaker, sir, Honorable Utim, in his lopsided assessment of performance, pointed to only one aspect of the mandate of the ICAC. I think this is unfair. The achievements of an institution like the ICAC cannot be measured solely in terms of investigation outcomes. It should be recalled that, besides investigation, the ICAC is also mandated to carry out corruption prevention and education functions, as well as manage declaration of assets and liabilities. As regards investigation, for the period 2016 up to now, which include the COVID period, ICAC referred 520 cases to the DPP. 325 were recommended for no further action, and prosecution was recommended in 195 cases, involving 236 suspects. Out of the 195 cases, 80 relate to corruption, and 109 for money laundering, and 6 to both money laundering and corruption. Moreover, for the same period, 164 other cases have been lodged before the Financial Crime Division, involving 218 suspects. ICAC has also secured convictions in 106 cases, out of which 47 were corruption cases and 59 money laundering cases. These convicted cases have led to either imprisonment, community service, or payment of fines amounting to approximately 20.5 million rupees. Moreover, during the same period, the ICAC seized and attached illicit asset to the tune of nearly 2.5 billion rupees. Under its education mandate, the ICAC has inter alia conducted numerous sensitization campaigns targeting the public sector, the education sector, the private sector, and the civil society whereby some 500,000 persons have been reached through face-to-face contacts. Organize empowerment sessions, workshops, seminars, conferences, and fora on specific issues such as procurement, recruitment and selection, inspection and ethics and integrity. Develop anti-corruption materials and tools to support the education campaign. Produce numerous e-learning modules which are available on the ICAC model platform, and set up and service anti-corruption platforms to enlist the engagement of private sector, civil society, academia, and youth through the public-private platform against corruption, the trade union against corruption, and integrity clubs in secondary schools. Under its prevention mandate, the ICAC exercises vigilance and superintendence over integrity systems in public bodies. In this endeavor, a collaborative and risk-based approach is adopted, whereby corruption risks are identified and recommendations are provided to enhance systems, procedures, and practices in public bodies. Mr. Speaker, sir, regional and international cooperation are crucial components of the global strategy to fight corruption. Over the years, ICAC has strengthened links with peer organizations and other international organizations to allow for sharing of best practices and mutual learning. ICAC's participation in the G20 Anti-Corruption Working Group has provided, among others, an opportunity for Mauritius to strengthen networks with G20 countries, as well as reinforcing working relations with international organizations. The ICAC actively contributed in the drafting and finalization of G20 high-level principles, reflecting the priority issues of G20. ICAC is also working closely with the SADC and African Union Advisory Board Against Corruption on a number of initiatives, including capacity building programs and on the development of alternative anti-corruption indicators. Currently, ICAC is working on the setting up of a regional financial crime training institute in collaboration with the United Kingdom Foreign Commonwealth and Development Office to service the African continent by meeting the growing needs for specialized training on financial crime detection, prevention, investigation, and prosecution. The ICAC, as we all know, is also the depository of all declarations of assets under the Declaration of Assets Act, and it is also responsible for their monitoring. Since 2019, the ICAC has received 6,403 such declarations and collected penalties amounting to more than 5.6 million rupees. The ICAC initiates the monitoring exercise of the assets and liabilities of declarants, their spouse, and minor children on a risk-based approach. Monsieur le Président, l'histoire retiendra qu'à chaque fois qu'un projet de loi est présenté dans cette auguste assemblée pour accentuer le combat contre la mafia de la drogue et tout autre criminel en col blanc, l'opposition parti travailliste, PMSD, et maintenant ajouter à cela le Boda, l'honorable Boda, je ne sais pas de quel parti il est, parce que j'avais appris ce matin qu'il allait être présent. Il a eu des directives, s'il vous plaît, de son leader. Son leader, c'est pas l'honorable, M. Ramavalaiden, qui avait publié formellement une directive pour lui dire que son député allait être présent, mais qu'au moment du discours de l'honorable Attorney General, il allait se retirer. Mais je ne sais pas, en cours de route, peut-être il a eu un autre leader. Hein? Peut-être il a commencé à se rattacher au docteur Navin Ramgoolam. On verra avec le temps. Mais en tout cas, cette opposition Parti Travail, PMSD, MMM et Boda, ils se sont opposés à chaque fois, véhément, contre ces projets de loi. Et à entendre leur vocifération lors des débats dans cette Chambre, certains croiraient qu'ils sont des grands défenseurs des droits fondamentaux de la population. Mais comme on sait, Monsieur le Président, dans la réalité, c'est un show de mauvais goût à répétition, un spectacle concocté pour induire des gens en erreur, une astuce pour cacher leur vrai agenda. Loin de se soucier des droits et des libertés de la population, ils viennent surtout pour défendre les intérêts des multiples mafias qu'ils ont engendrés, soutenus et protégés durant leur règne maléfique. Tout le cinéma qu'on a vécu mardi et vendredi dernier dans cette Chambre découle du fait que l'opposition travailliste PMSD s'est rendu compte que le Financial Crimes Commission Bill que j'ai présenté va encore faire mal à ces mafias que je viens de mentionner. Ils sont vexés parce que ce sont leurs sources de financement, leurs war chests politiques qui sont menacés. Le temps est venu confirmer, Monsieur le Président. Comme j'ai dit, les masques tombent et les masques vont continuer à tomber. La connexion entre le Parti travailliste, le PMSD et la mafia de la drogue dont j'ai parlé. Vous voulez des exemples? Je vous les énumère. L'ami de Nita, un certain AD, grand agent du Parti travailliste à Belle-Rose, Quatre-Beaunes, a récemment été condamné aux assises à 40 ans de prison pour trafic de drogue, d'héroïne, d'une valeur marchande de 30 millions de roupies. Un certain Jonathan A, alias Tipapier, qui ne connaît pas Jonathan A, alias Tipapier, hein, très proche du leader du Parti travailliste, a fait l'objet d'une enquête concernant le trafic de drogue et le blanchiment d'argent. Il a été condamné déjà pour outrage à la cour. Monsieur Vimen S, bodyguard du leader du Parti travailliste, a été arrêté pour possession de tant de kilos d'héroïne d'une valeur de 155 millions de roupies. Un certain, il va se reconnaître, M-R-G-K-C-T-M, qu'on appelle plus communément Michael, chauffeur attitré d'un honorable Patrick, dans la circonscription numéro 18, durant la campagne de 2014, a été arrêté pour possession et trafic de drogue, après la saisie à son domicile de drogue de 7,3 kilos de cannabis et autant d'autres choses aussi que je n'énumère pas. Un certain monsieur Akil B, membre du Parti travailliste, s'il vous plaît, a été arrêté en compagnie de sa concubine pour possession de drogue d'une valeur de 260 000 roupies. Ce même individu a été arrêté pour importation de drogue, en l'occurrence 1022 comprimés d'ecstasy d'une valeur supérieure à 20 millions de roupies. Un autre individu adoré et ouvertement défendu par le leader du Parti travailliste et d'autres dirigeants du Parti travailliste. Celui-là, je l'appelle, c'est un star, un certain Bruno L. Je ne parle pas de BLD, hein, je parle de BL seulement. A été arrêté pour possession d'hachis d'une valeur supérieure à 221 millions de roupies. Voyez, Monsieur le Président, combien d'argent peuvent faire fructifier ces marchands de la mort et pourquoi ils viennent défendre. J'ai dit pourquoi. Le Parti travailliste, le PMSD, jamais ils ont voulu mettre sur pied une commission d'enquête pour enquêter sur le trafic de drogue. Pendant presque de 10 ans qu'ils étaient au pouvoir. Nous l'avons fait. Et maintenant que nous implémentons les mesures, les recommandations qui ont été faites par la commission Lam Changlin, là aussi, ils viennent essayer d'empoisonner l'esprit des gens. Donc, Monsieur le Président, on peut facilement comprendre la raison de l'énervement et l'acharnement des députés travaillistes dans cette Chambre. Leur intérêt et de ceux de leurs amis mafieux sont en danger. Alors, il fallait s'attaquer à ce projet de loi. En ce qui concerne le PMSD, qui ne connaît pas leur proximité avec une certaine Cindy, qui transitait par le VIP Lounge à l'aéroport SSR sur intervention n'est pas là, l'honorable Richard Duval, pour faire entrer des milliers de comprimés Subitex dans le pays. On comprend encore mieux aujourd'hui pourquoi le Parti travailliste et le PMSD au pouvoir n'ont jamais, comme j'ai dit, institué une commission d'enquête sur la drogue. On comprend aussi pourquoi ils n'ont pas soutenu le projet de loi sur le financement politique. Monsieur le Président, en ce qui concerne les positions adoptées par les députés du MMM sur le projet de loi devant la Chambre, elles sont encore remplies d'hypocrisie et de malhonnêteté. Dois-je rappeler que le MMM, qui se gargarise du slogan « la main propre », n'a pas hésité une seconde à encaisser les 10 millions venus de la BAI, qu'il avait pourtant dénoncé, l'honorable Béranger lui-même avait dénoncé en premier pour des transactions financières illicites opérées par le biais d'un Ponzi scheme. Comment, Monsieur le Président, quelqu'un qui vient dire qu'une compagnie est en train de voler l'argent de la population, lui-même, il accepte, il tale la main avec son catori, il accepte, il demande à M. BAI, donnez-moi un petit argent, une petite contribution pour les élections, et il oublie tout d'un coup ce qu'il avait dit pendant des années concernant la BAI. Et a-t-on oublié, Monsieur le Président, comment et avec quelle verve le député Outim avait défendu un caïd de la drogue sur le plan international, un certain Peter Jurisek, que les autorités mauriciennes avaient logiquement remis aux autorités slovaques. Ce criminel que d'autres membres de l'opposition avaient aussi défendu dans cette Chambre a été condamné à 22 ans de prison en Slovaquie pour fabrication, possession et trafic de drogue. La population avait pu constater comment ces membres de l'opposition, incluant l'honorable Outim, qui souvent agissent en donneurs de leçons, se sont mis dans le camp d'un marchand de la mort. Ils ont soutenu un homme dangereux qui voulait contracter un mariage de convenance avec une Mauricienne pour se réfugier dans notre pays et faire son odieux business et mettre en péril la vie de nos enfants, la vie de nos jeunes, la vie de notre population. Quant à l'honorable Boda, il me fait pitié. Il a parlé de la nécessité de couper les liens entre la mafia et la classe politique. Mais force est de constater qu'après avoir été largué comme du Jean Malak par le leader indien de confiance, il est allé se livrer dans les bras d'un homme qui lui-même s'est autoproclamé le parrain des émeutes que notre pays ait vécues. Quelqu'un connu pour ses connexions mafieuses. Quelle honte! Monsieur le Président, on a aussi témoigné les récriminations des membres de l'opposition concernant la réglementation sur le réenregistrement des cartes SIM. Pourtant, cette initiative découle d'une recommandation de la commission d'enquête Lam Changling sur le trafic de drogue. Et le but est de traquer les marchands de la mort et autres criminels qui mettent notre population en danger. L'opposition, elle, parle d'espionnage. Mais dans la réalité, c'est encore une fois l'intérêt de leurs amis et partenaires mafieux qu'elles défendent et souhaitent protéger. Les masques des membres de l'opposition continuent de tomber, Monsieur le Président. Et ils osent nous pointer du doigt. Cette opposition est indigne et suscite le mépris. Le peuple saura, j'en suis convaincu, juger ses membres de l'opposition en temps et lieu. Monsieur le Président, en tant que Premier ministre à la tête d'un gouvernement responsable, nous n'avons pas d'agenda caché. Le Financial Crimes Commission Bill vient renforcer notre arsenal législatif pour combattre les crimes financiers. Ces crimes sont liés au trafic de drogue, au blanchiment d'argent, au monde des jeux et aussi à certaines autres activités occultes comme le financement du terrorisme. Nous implémentons avec courage les recommandations du Financial Action Task Force, de l'Eastern and Southern Africa Anti-Money Laundering Group, ESAMLAG, de l'OCDE et de la commission d'enquête sur la drogue, pour que Maurice adopte les meilleures pratiques mondiales dans la lutte contre le blanchiment d'argent et le financement des activités occultes. Nous n'avons pas de sinistre motif, comme veut faire croire l'opposition. Et contrairement au Parti travailliste qui, au pouvoir, a utilisé les institutions à des fins de vendetta politique. Je sais de quoi je parle avec ce que j'ai vécu moi-même dans l'affaire Medpoint, où le régime travailliste et ses hommes a tout fait pour placer dans des institutions, ont tout tenté de me culpabiliser pour un délit que je n'ai jamais commis. C'était le temps des complots politiques. Ça s'appelle le complot politique. Et du règne des tontons macoutes du régime machiavélique de Navin Ramgoolam. Et ils ont le culot, ces députés du Parti travailliste, de venir nous accuser de vouloir se servir des dispositions de ce projet de loi à des fins de victimisation politique. Monsieur le Président, j'ai présenté durant mon intervention des arguments documentés et solides pour démontrer qu'il n'y a aucun danger pour les libertés, pour la démocratie, ou encore pour le poste de directeur des poursuites publiques. Ce projet de loi que nous présentons n'est pas une loi scélérate, comme l'a décrit l'honorable Paul Béranger vendredi dernier. C'est une loi qui, au contraire, vise des scélérats précisément. De ce côté de la Chambre, nous sommes des progressistes. Les lois ne peuvent demeurer statiques quand les criminels utilisent tous les moyens technologiques pour poursuivre leurs activités illicites. Nous avons le devoir de nous donner l'arsenal légal et les moyens nécessaires pour combattre efficacement les crimes financiers. Avec l'adoption par l'Assemblée nationale du Financial Crimes Commission Bill, notre pays se mettra au diapason des juridictions internationales les plus crédibles et dont les institutions seront plus aptes à agir de manière efficace contre tous ceux qui daigneront s'engager dans le trafic de drogue, le blanchiment d'argent et d'autres crimes financiers. Ce pas en avant, Monsieur le Président, va nous permettre à mieux appréhender la nouvelle évaluation de ESAMLAG, du FATF, de l'OCDE, de notre juridiction financière. Une évaluation qui sera cette fois-ci axée sur l'efficacité de nos institutions dans le combat contre les crimes financiers. Aucun complot de l'opposition, aucune fausse propagande, aucune menace ne va m'arrêter dans ma mission à combattre ces mafiosi qui mettent en péril la vie de nos compatriotes et la réputation de notre République. Mr. Speaker, sir, on Tuesday last, I heard both Honorable Boulel and Honorable Shakil Mohammed stating very forcefully and theatrically in this House that once the Labour Party will be in power, they are going to scrap this piece of legislation. Well, first of all, they are not going to be in power anytime soon. But if ever by misfortune they accede to power someday, yes, we presume they will repeat what they did in 2006 and 2011 when they dismembered the polka to suit their convenience and interests of their leader, and clear the way for him to fill up his coffers with unexplained liquid money, including freshly packed foreign currency in all impunity. Anyway, we do not expect anything better from them, but we know that the people of this country will send them back to the Kaokan where they deserve to be. Mr. Speaker, sir, financial crimes have remained a significant and constantly evolving threat to both national and global stability and security of societies, undermining institutions, principles and values of democracy, human rights, ethical values, and also jeopardizing the rule of law and economic stability and investor confidence. Their growing complexity and sophistication represent an evolving challenge to law enforcement agencies in all countries around the world. And as a responsible government, we have no alternative but to act with foresight and undertake periodic assessment of our current financial crimes framework and take appropriate remedial measures in order to maintain its effectiveness. The ongoing objective should be to identify ways in which the different agencies can work together in combating financial crimes and delivering better results in shorter time frames and at lower costs. This is precisely the central objective of this bill, through which this government is demonstrating its seriousness of purpose in sustaining the reforms and to continuously build a robust regime in the fight against financial crimes by addressing identified gaps and adhering to best practices. Mr. Speaker, sir, as I stated in my second reading speech, I shall be proposing certain minor amendments to the bill at committee stage. The proposed amendments have already been circulated. Mr. Speaker, sir, the opposition have raised questions over the timing of the introduction of the bill. Upon hearing their arguments, I recall what Albert Camus used to say, and I quote, "Those who lack the courage will always find a philosophy to justify it," unquote. Mr. Speaker, sir, I am also reminded of what Mr. Martin Luther King Jr. very rightly said, and I quote, "The time is always right to do what is right," unquote. Mr. Speaker, sir, this bill is a major and decisive step in the right direction, as the measures embodied therein will fortify the pillars of our economy, of our country's economic integrity and societal trust. And it is therefore a bill that serves the national interest. I will conclude on this note by quoting Albert Einstein, who once said, and I quote, "The world is a dangerous place, not because of those who do evil, but because of those who look on and do nothing," unquote. Mr. Speaker, sir, this government has decided to act and do something, and our response is embodied in this bill. Thank you, Mr. Speaker.
Motion seconded. The question is that the Financial Crimes Commission Bill number 20 of 2023 be read a second time. Those in favor say aye, those against say no. The ayes have it.
Public Bill Committee stage. Clause 1 short title.
Question is that clause 1 and part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 2 interpretation.
Mr. Speaker, sir, I move that clause 2 be amended as per amendment circulated.
The question that clause 2 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 2 as amended stands part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 3, the Commission. Clause 4, the Commission. Clause 3, application of Act. Clause 4, the Commission. Clause 5, divisions of Commission.
Question that clauses 3 to 5 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 6, functions and powers of Commission.
Mr. Speaker, sir, I move that clause 6 be amended as per amendment circulated.
The question that clause 6 be amended as per amendment circulated in favor say aye, those against say no. Ayes have it. The question is that clause 6 as amended stands part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 7, composition of Commission. Clause 8, meetings of Commission. Clause 9, secretary to Commission. Clause 10, director general.
Question that clauses 7 to 10 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 11, functions and powers of director general.
Mr. Speaker, sir, I move that clause 11 be amended as per amendment circulated.
The question that clause 11 be amended as per amendment circulated. Those in favor say aye, those against say no. Ayes have it. The question that clause 11 as amended stands part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 12, vacancy in office of director general. Clause 13, termination of appointment of director general. Clause 14, director of division. Clause 15, chief legal advisor. Clause 16, head of unit. Clause 17, officers of commission. Clause 18, use of independent professionals. Clause 19, bribery by public official. Clause 20, bribery of public official. Clause 21, taking gratification to screen offender from punishment. Clause 22, public official using his office for gratification. Clause 23, bribery of or by public official to influence the decision of public body. Clause 24, influencing public official. Clause 25, traffic d'influence. Clause 26, public official taking gratification. Clause 27, bribery for procuring contracts. Clause 28, bribery for procuring withdrawal of tenders. Clause 29, conflict of interest. Clause 30, treating of public officials. Clause 31, receiving gift for corrupt purpose. Clause 32, corruption in private entities. Clause 35, corruption to provoke serious offense. Clause 34, bribery by or of foreign public official. Clause 35, corruption in relation to sporting events. Clause 26, money laundering. Clause 27, limitation of payment in cash. Clause 38, alleged proceeds of crime. Clause 39, fraud by false representation. Clause 40, fraud by failing to disclose information. Clause 41, making or supplying articles for use in fraud offense. Clause 42, failing to pay for goods and services. Clause 43, fraud by abuse of position. Clause 44, electronic fraud. Clause 45, financing of drug dealing.
Question is that clauses 12 to 45 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 46, making or supplying articles. Clause 47, possession of articles. Clause 46, Clause 48, conspiracy. Clause 49, aiding, abetting or counseling. Clause 50, attempt. Clause 51, penalty for breach of guidelines. Clause 52, obligations of legal persons. Clause 53, liability of legal persons. Clause 54, notification of financial crimes and other offences. Clause 55, duty to report financial crimes and other offences. Clause 56, referrals to commission. Clause 57, preliminary investigation by commission. Clause 58, further investigation by commission. Clause 59, power of examination. Clause 60, power of entry and search. Clause 61, seizure of property. Clause 62, power of arrest. Clause 63, disclosure of financial transactions and any other information. Clause 64, order to search specified premises. Clause 65, telecommunication order. Clause 65, special investigation techniques. Clause 67, discharge or variation of order under Part 4.
The question that clauses 46 to 67 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 68, application of Part 5. Clause 69, application for criminal attachment order. Clause 70, issue of criminal attachment order. Clause 71, management of property under criminal attachment order. Clause 72, judges further orders. Clause 73, exclusion of property from criminal attachment order. Clause 74, registration of criminal attachment order. Clause 75, contravention of criminal attachment order. Clause 76, duration of criminal attachment order. Clause 77, application for criminal confiscation order. Clause 78, service of criminal confiscation registration of the application. Clause 79, issue of criminal confiscation order. Clause 80, determination of value of benefit. Clause 81, amount recoverable. Clause 82, discharge of criminal confiscation order. Clause 83, appeal against criminal confiscation. Clause 84, realization of property under criminal confiscation order. Clause 85, application of monetary sums. Clause 86, contravention of criminal confiscation order. Clause 87, application for civil attachment order. Clause 88, issue of civil attachment order. Clause 89, management of property under civil attachment order. Clause 90, exclusion of property from civil attachment order. Clause 91, order in respect of immovable property. Clause 92, variation and rescission of civil attachment order. Clause 93, duration of civil attachment order. Clause 94, contravention of civil attachment order.
The question that clauses 68 to 94 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 95, application for civil confiscation order. Clause 96, issue of civil confiscation order. Clause 97, failure to notify. Clause 98, exclusion of property from civil confiscation order. Clause 99, appeal against civil confiscation order. Clause 100, enforcement of civil confiscation order. 101, recoverable property. Clause 102, property indirectly obtained or used. Clause 103, property and not recoverable. Clause 104, application for compensation order. Clause 105, issue of compensation order. Clause 106, foreign request in connection with civil asset recovery. Clause 107, foreign request for enforcement of foreign civil attachment order, civil confiscation order. Clause 108, effect of registration of foreign order. Clause 109, foreign request for the location of tainted property. Clause 110, disposal of proceeds of crime. Clause 111, proceedings in foreign state. Clause 112, application of Part 6. Clause 113, reporting of unexplained wealth.
The question is that clauses 95 to 113 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 114, investigation into unexplained wealth.
Mr. Speaker, sir, I move that clause 114 be amended as per amendment circulated.
The question is that clause 114 be amended as per amendment circulated. Those in favor say aye, those against say no. Ayes have it. The question is that clause 114 as amended stands part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 115, application for disclosure order. Clause 116, inscription of privilege or loan. Clause 117, application for unexplained wealth order. Clause 118, service of unexplained wealth order application. Clause 119, issue of unexplained wealth order. Clause 120, appeal against unexplained wealth order. Clause 121, enforcement of explained wealth order. Clause 122, reward. Clause 123, protection of informers. Clause 124, protection of witnesses. Clause 125, witness protection scheme.
Question that clauses 115 to 125 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 126, operations review committee.
Mr. Speaker, sir, I move that clause 126 be amended as per amendment circulated.
The question that clause 126 be amended as per amendment circulated. Those in favor say aye, those against say no. Ayes have it. The question is that clause 126 as amended stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 127, proceedings of operations review committee. Clause 128, functions and powers of operations review committee. Clause 129, parliamentary committee. Clause 130, proceedings of parliamentary committee. Clause 131, functions and powers of parliamentary committee. Clause 132, national coordination committee. Clause 133, functions of national coordinating committee. Clause 134, meetings of national coordination committee. Clause 135, public-private partnership task force. Clause 136, functions of public-private partnership task force. Clause 137, meetings of public-private partnership task force. Clause 38, sharing of information and intelligence.
The question that clauses 127 to 138 stand part of the bill. Those in favor say aye, those against say no. Ayes have it.
Clause 139, memorandum of understanding for mutual cooperation.
Mr. Speaker, sir, I move that clause 139 be amended as per amendment circulated.
The question is that clause 139 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question that clause 139 as amended stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 140, Memorandum of Understanding for sharing of information.
Mr. Speaker, sir, I move that clause 140 be amended as per amendment circulated.
The question is that clause 140 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 140 as amended stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 141, Offences and Jurisdiction. Clause 142, Prosecution. Clause 143, Acts committed outside Mauritius. Clause 144, Admissible Evidence. Clause 145, Burden of Proof with regard to corruption offence. Clause 146, Ordering deprivation of monetary benefits and property. Clause 147, Ordering compensation for loss or damage. Clause 148, Confiscation of property. Clause 149, Civil and Administrative sections. Clause 150, compounding of offences. Clause 151, General Fund. Clause 152, Recovered Assets Fund. Clause 153, Accounts of Commission. Clause 154, Estimates. Clause 155, Annual Report. Clause 156, Audit Report. Clause 157, Exemptions. Clause 158, Donations and Legacies. Clause 159, Recovery of Damages. Clause 160, Disclosure of Assets and Liabilities.
The question that clauses 141 and to 160 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 161, Confidentiality.
Mr. Speaker, sir, I move that clause 161 be amended as per amendment circulated.
The question is that clause 161 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 161 as amended stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 162, Protection from Liability. Clause 163, Directives. Clause 164, Regulations. Clause 165, Repeal.
The question that clauses 162 to 165 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 166, Consequential Amendments.
Mr. Speaker, sir, I move that clause 166 be amended as per amendment circulated.
The question is that clause 166 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 166 as amended stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 167, Employment of Officers of ICAC, ARID and ESA. Clause 178, Order, Other Savings and Transnational Provisions. Clause 169, Commencement.
The question that clauses 167 to 169 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
The first schedule.
The question that the first schedule stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
The second schedule.
The question is that second schedule stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
The title and enacting clause.
The question is that title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. The question is that I do report to the House that the Financial Crimes Commission Bill number 20 of 2023 has passed a committee stage with amendment. Those in favor say aye, those against say no. The ayes have it. Please be seated. Honourable members, I have to report to the House that the Financial Crimes Commission Bill number 20 of 2023 has passed the committee stage with amendments.
Third reading.
I move that the Financial Crimes Commission Bill number 20 of 2023 be read a third time and passed.
Seconded. The question is that the Financial Crimes Commission Bill number 20 of 2023 be read the third time and passed. Those in favour say aye, those against no. The ayes have it.
Motion.
Mr. Speaker, sir, thank you for giving me the opportunity to participate in the debates on this very important motion, the report of the Electoral Boundaries Commission on the review of the boundaries of the constituencies. This report was released in 2020 and was laid on the table of the National Assembly subsequently. Today, we are being asked to approve the report in conformity with Section 39(4) of the Constitution of Mauritius. And as we know, sir, this August Assembly can accept or reject the Commission's recommendation by resolution, but it cannot change them. If the House decides to accept the recommendations, they will take effect after the next dissolution of Parliament. In line with Section 39 of the Constitution, the Electoral Boundaries Commission is mandated to review constituency boundaries every 10 years and offer recommendations for any changes the Commission deems necessary to ensure that each constituency's population is as close to the population quota as is practically possible. Sir, Section 39(9) defines population quota as the number obtained by dividing by 20 the number of inhabitants of the island of Mauritius, including any island included in any constituency in the island of Mauritius by virtue of any resolution under subsection 1 according to the latest official census of the population of Mauritius. The population quota, sir, derived from the 2011 population census stands at 59,832, and this figure serves as the guiding principle of the current boundary delimitation exercise. The foremost objective is to ensure that constituencies are as closely balanced in terms of population as possible, so that each citizen's vote carries a similar weight. Mr. Speaker, sir, our nation has always held democracy as a sacred value, and we have strived to uphold it through the years and decades. Free and fair elections are the cornerstone of any true democracy, and it is our duty in this House to ensure that the electoral process remains transparent, impartial, and accessible to all citizens. Our electoral system returns elected members in our 21 constituencies on the basis of a first 3 past the post mode in the island of Mauritius and a first 2 past the post mode in Rodrigues before the designation of best losers. Constituencies are fundamental to the democratic process, as they are the basis for the representation of citizens' interests in the governance of the country. They are designed to ensure that every citizen has a voice in Parliament, to the extent that each constituency elects its own representatives to the National Assembly, who are responsible for representing the interests and concern of the constituents. This is the essence of democracy. The voice of the people should be heard, and their will should be reflected in the composition of this August Assembly. Consequently, sir, the delimitation of electoral boundaries is equally vital and lies at the heart of our democracy. The Electoral Boundaries Commission report is not just a technical document. It is a symbol of our commitment to these democratic principles. The boundaries it defines must ensure that constituencies are evenly balanced in terms of population, thus preventing any group from being underrepresented or overrepresented. This balance is crucial to prevent the distortion of the electoral process and to maintain the principle of one man, one vote. The report outlines the delimitation of constituencies, a task that is crucial for distributing political representation fairly among our diverse population. The importance of this task cannot be overstated, as it directly affects the power of our citizens to elect their representatives and participate in the governance of our nation. The Electoral Boundaries Commission, sir, has reviewed the boundaries of the constituencies in our country, as we know, and presented 4 reports to the Assembly, namely in 1976, 1986, 1999, and 2009. The recommendations of the 1986 and 1999 reports were approved by the Assembly, whilst those of the 1976 report were rejected. The 1986 report, sir, was the most hotly debated boundary delimitation review, and the issue of gerrymandering, which, as we know, is the deliberate manipulation of electoral boundaries to favor one political party or group over others, took center stage in those debates at that time. The exercise of delimiting new boundaries has been plain sailing so far in our country. And it is vital, sir, that we safeguard our democratic tenets and practice in our electoral process. It is our responsibility as representatives of the people to ensure that this report upholds the principle of free and fair election and that it is testament to the strength of our democracy. Furthermore, the report must ensure that boundaries are drawn without bias or favoritism. The Electoral Boundaries Commission is an independent institution set up under the Constitution. We have every reason to believe that the Commission has acted with the utmost integrity, impartiality, and transparency. Political considerations or gerrymandering should never influence the delineation of constituencies, as this would undermine the very essence of our democracy. In that sense, sir, I think we were all shocked at the last sitting when we saw the reaction of Honorable Osman Mohamed, who expressed his comments and his opinion concerning this report. Mr. Speaker, sir, the founding fathers of our Constitution have introduced inbuilt safeguards to prevent gerrymandering by ruling parties. This is precisely why the report should be either accepted in toto or rejected in toto. Had it not been the case, ruling parties would have misused their majority in the House, or could have misused their majority in the House to pick and choose those parts of the report that favor their interest. Especially as we know, the motion to adopt the report needs a simple majority and not a 2/3 or 3/4 majority. They could have gerrymandered to redraw electoral constituency lines in a way that favors the ruling party. This can involve creating oddly shaped constituencies that concentrate opposition voters into a few constituencies, a tactic known as packing, or dispersing them thinly across numerous constituencies, a tactic known as cracking. Sir, had the possibility to pick and choose existed, unprincipled ruling parties may choose to ignore demographic changes, such as population shift or changes in the composition of a constituency when redrawing boundaries. This would have resulted in the underrepresentation of certain groups or the dilution of their voting power. The current review mechanism and the inbuilt safeguards are probably the best system we could have, given the risk and temptation of manipulation by dishonest politicians. Mr. Speaker, sir, when electoral boundaries are not rebalanced or adjusted periodically, it can create opportunities for the manipulation of the voting system to capture the vote by particular groups or political parties. In areas with rapidly changing demographics, vote dilution can occur when electoral boundaries are not adjusted to accommodate these changes. The votes in a constituency which has grown disproportionately relative to the population quota may be diluted, making it difficult for some groups of voters to elect representatives who truly represent their interests. Vote dilution occurs when the population of a specific constituency significantly surpasses a defined population quota, which in the case of Mauritius stands at 59,832. Addressing vote dilution is a fundamental objective of any electoral boundaries delimitation review. It is essential for electoral boundaries to be periodically revisited and adjusted at reasonable intervals. In UK, sir, this is a very regular practice. This exercise takes place very regularly, and there have been cases after the delimitation process has taken place, some MPs even lose totally their constituency because the parts of the specific constituency have been transferred to other neighboring constituencies. This process should be conducted transparently and impartially, taking into account changing demographics, geographic consideration, and the need to ensure fair and equal representation for all citizens. Electoral boundaries commissions or similar bodies in mature democracies like ours play a crucial role in maintaining the integrity and legitimacy of the electoral system. Mr. Speaker, sir, today we have the opportunity to address some very striking discrepancies in our constituency-based vote system. According to the register of electors in force at the time of the preparation of the 2020 Electoral Boundaries Commission report, that was in 2020, the two largest constituencies in terms of electors, namely constituencies number 5 and 14, have 65,115 in the case of number 5 and 63,500 in the case of constituency number 14, respectively. Today, the figures of 2023 show that constituency number 5 has reached 70,269, and constituency number 14 has reached 67,770 electors, respectively, Mr. Speaker, sir. The smallest constituency is constituency number 3, with 21,943 electors. This ratio in respect of the constituencies with the highest number of electors and constituency with the lowest number of electors is nearly 3 to 1. In fact, when we look at the latest figures of 2023, in the case of number 5, it is 3.5 to 1. In the case of 14, it is 3 to 1. This is very much illustrative of the risk scenario where the weight of one person's vote in an overpopulated constituency is much less than the weight of a vote in an underpopulated constituency. This compromises the equity and equality of representation and goes against the principle of one person, one vote concept. Mr. Speaker, sir, this is why we are seeing some sizable shift in some of the overpopulated constituencies, which as a matter of fact include mine, constituency number 14, Savan Black River. And in the case of my constituency, the Commission, in the case of constituency number 14, the Commission has recommended that localities of Route Bassin, Résidence Kennedy and Palma be distracted and be annexed to constituency number 18, Belle Rose, Quatre-Bonnes. These recommendations would result in a decrease of 16,242 electors from constituency number 14. In fact, it is the biggest shift, it is the biggest transfer of electors according to this exercise, Mr. Speaker, sir. As a result of the recommendations made in this report, the constituency with the highest number of electors now will be constituency number 18 with 58,267 electors, and the lowest number of electors will be in constituency number 2 with 29,962 electors. The ratio now between the highest and the lowest number of electors will stand at nearly 2 to 1. Sir, we nonetheless have to acknowledge that in even the most populous and advanced democracies, achieving perfect parity in constituency population quotas is a recognized and accepted challenge, and Mauritius is no exception. As the Commission observed in its report, the population within constituencies is in a constant state of flux due to infrastructural and residential developments, population migration, making it impractical to mechanically enforce an identical population quota for every constituency. This understanding is underpinned by the wisdom of our constitution framers, who explicitly, Mr. Speaker, sir, acknowledge that a constituency's population could vary for various reasons. It is essential to strike a balance between ensuring some flexibility in constituency populations while avoiding extreme disparities. Mr. Speaker, sir, it is worth noting that the Commission acknowledges the historical context in which constituency boundaries were initially established. We all appreciate that designing of some electoral boundaries was the outcome of very complex and intense political negotiations between the political leaders ahead of independence. Before 1967, Mauritius was divided into 40 constituencies, and one member of parliament was elected from each constituency. Afterwards, the 40 constituencies have been paired and reorganized to form a total of 21 constituencies, 20 for the island of Mauritius, with each returning 3 MPs and 1 for Rodrigue, based on the first past the post system, and and prior to the designation of best losers. We all understand that the redesigning of electoral boundaries ahead of the 1967 general elections was not purely a mechanical reorganization exercise, sir. They were very complex and sensitive motives, considerations behind this fundamental redesigning of constituencies. Despite the Commission's best efforts and adherence to its constitutional mandate, it has no right and it cannot redefine the constituency boundaries of the island, of the country. Mr. Speaker, sir, the application of the recommendations of the Commission will depend on the next updated electoral register. According to the Representation of the People's Act, every register compiled in any year shall come into force on the 15th of August in that year and shall remain in force until the next register is compiled. Therefore, the next register in August 2024 will reflect the new constituency delimitation, and it is only then that the recommendations of the Commission will come into effect. Furthermore, as we know, according to Section 39(4) of the Constitution, the Assembly may approve the resolution and the recommendations shall have effect as from the next dissolution of Parliament. Monsieur le Président, pour conclure, personnellement, c'est avec beaucoup de peine que je vais me séparer de ces quelques 16 000 personnes venant de Route-Bassin, résidence Kennedy et Palma, dont j'ai eu le privilège de représenter au Parlement et de servir avec vous pendant 5 ans, Monsieur le Président, et de servir pendant plus de 40 ans. Avec ce transfert de 16 233 électeurs exactement, la circonscription numéro 14, comme je viens de le dire, subit le changement le plus important dans cet exercice de redécoupage. Monsieur le Président, entre moi et les mandants de Route-Bassin, Kennedy et Palma, ça a été une très belle aventure. Une aventure humaine avant tout. Une histoire d'amour, je dirais, Monsieur le Président, qui a duré pendant les derniers 41 ans. Ceux qui me connaissent savent que j'ai été toujours à l'écoute de mes mandants, de leurs attentes, de leurs préoccupations et de leurs aspirations. Je vais manquer ce contact chaleureux avec mes amis de Bassin, de Palma et de Kennedy. Ce fut un honneur de pouvoir les servir. Mais ils savent qu'ils pourront toujours compter sur moi. D'ailleurs, dans le cadre de ce nouveau redécoupage, leurs localités seront annexées à la circonscription numéro 18, Belle-Rose-Quatre-Bornes, une circonscription qui avoisinera la nôtre. Au cours de ces dernières années, nos deux circonscriptions ont développé un lien spécial, grâce notamment à l'engagement de la PPS Tania Diol, mon collègue de parti, dans les différents quartiers, non seulement de 14, mais aussi dans les quartiers de Belle-Rose et de Quatre-Bornes, Monsieur le Président. L'esprit de la Constitution et l'intérêt supérieur du pays doivent primer. Et en tant qu'hommes ou femmes politiques, il nous faut être toujours prêts à retrousser nos manches et affronter des nouveaux challenges. Étant un vieux de la veille, tout en regrettant l'excision de ces 3 localités de ma circonscription, qui est la plus grande en passant géographiquement, elle est d'environ 330 km², Monsieur le Président. Tout en regrettant cette excision, je suis déjà prêt avec mes collègues de la circonscription à reprendre la conquête de l'Ouest et au Sud-Ouest et de maintenir notre suprématie dans la nouvelle circonscription qui a été découpée. C'est un optimisme inébranlable qui nous anime et motive. Pour conclure, je tiens à féliciter le Electoral Boundaries Commission pour l'excellent travail qu'elle a abattu. C'est une tâche extrêmement complexe et sensible qui a été réalisée, je comprends, au terme de beaucoup de consultations, d'analyses et de site visits. Mes appréciations vont aussi au bureau de la Commission électorale et à tous les autres organismes qui ont participé à la réalisation de cet important document. Il incombe maintenant à nous, représentants du peuple, d'assumer notre responsabilité vis-à-vis de la constitution de la démocratie. J'en ai terminé. Merci de votre attention.
Honourable members, I'll suspend the sitting for 30 minutes.